Richmond Saka is his lawyer, and he's joined us on the line. Sir, you're welcome to Eyewitness News.
Thank you.
What's your initial... Good evening. What's your initial comment as a legal team representing George Afriyie, having seen the dismissal of your application for review?
Well, we received the decision of the appeals committee of the GFA sometime later in the evening yesterday, and obviously we are dissatisfied with the decision. We immediately took the view that the decision was made without regard to the case that was put before the appeals committee by George Afriyie. And so we advised him accordingly, and we've had the necessary instructions as to how to proceed.
When you disagree, which of the points raised do you disagree with?
Now, if you see the decision by the electoral committee of the GFA, there are two major points on the basis of which they decided they would effectively disqualify George Afriyie. The first was that he had breached Article 13(2)(j) of the Ghana Football Association Statutes 2019. So we took issue with that, and we addressed the appeals committee about that decision because that was one of the reasons for which they decided to disqualify. Now, if you look at Article 13(2)(j) of the GFA statutes, it has nothing to do with elections at all. It has nothing to do with elections at all. It has to do with becoming a member of the association. Membership of the association is by legal persons, not by natural persons. So there can be no way that George Afriyie could have breached that particular article of the statute, for which reason they were claiming they were disqualifying him. We addressed the committee on that. But you would find interesting that nothing at all was said about that address of the committee. We believe that the committee should have made a finding about that ground of our appeal because that was one of the bases for which the decision was made. Secondly, if you look at the decision of the committee, paragraph 2 of the decision on page 1, they tell you that they are resolving the issue basically without regard to the grounds of appeal that was raised by George Afriyie. However, we believe with all due deference to the appeal committee that that is supposed to be the purpose of that appeal, that you would consider the grounds raised, you would consider the submission made and the arguments raised, and come with an informed proposition about it, whether agreeing or otherwise. To disregard it altogether means that even the purpose of the appeal was disregarded. And so
your appeal, just to be sure, your appeal was on two grounds: one on breach of natural justice, and two on a wrong interpretation of the statute. You talk about 13(2)(3). Is that the one that talks about
J?
J.
13(2)(j).
Okay.
Of the GFA statute.
So 13 says any legal person wishing to become a member of the GFA shall apply in writing only to the General Secretary.
Exactly.
The application must be accompanied by the following mandatory documents. And J says a list of officials specifying those who are authorized signatories with the right to enter into legally binding agreements with third parties. Any changes of officials and authorized signatories shall be communicated in writing to the General Secretary within 30 days of the said change. So this is about admissions of what, members?
Exactly.
So you're saying that
these are legal persons, not natural persons.
Okay, so this could be an association. So these are the associations.
These are the members of the association. So the GFA, to become a member, you must be a legal person, duly constituted under law, and meeting the necessary requirements in Article 13(1), going down to Article 1 and 2. So
you're saying that this should not be relied on at all because it has nothing to do with the elections.
Exactly. If you want to talk about elections, you are going to other parts of the statutes of the GFA. And when you go to the necessary part of the statutes on the GFA about elections, you are looking at Article 30. That is the only statute in the GFA statute that talks about elections. Then that statute refers you to compliance with the regulations on elections, which they passed in 2019. If you look at the regulations, they also tell you what you can do to be eligible to stand office. The eligibility requirements, as I have said, and we submitted to the appeals committee does not include any formal completion of a form or document.
Okay, so I'm looking at the Article 30 that you wish they relied on.
Good.
I'm looking at point 4.
Mm-hmm.
It says that for the election of the constituent, it talks about nomination of persons, and that appears to be the problem for you, that your candidate or your client presented someone as a signatory to a club that was sponsoring or promoting him, but which person did not have the locus to represent that club. As a lawyer, that could even be described as fraud.
Now, you need to understand the statute in a certain context. Now, let's go back to the statute. The statute says that for the election of the constituent bodies onto the executive council, each candidate shall be proposed by one member and supported by one other member. Each member shall propose or support one candidate for each given position only. Now, let's go to 3, which is actually in contention. Article 33 says, the election for the position of the president shall take place by position. Each candidate for the position of president shall be proposed by one member and supported by 5 members.
And that is your problem. So
now, Omar, now we would now have to give interpretation to what has been provided here in the context of the election regulations and the statutes of the GFA. You understand? That is what we have to do. The rule says the person must be what? Proposed by one candidate and supported by 5 other members. By members, we mean legal persons.
So associations, so clubs.
Yes, so clubs. Now, if you go through the statute, you will not find anywhere they would say that when it comes to elections, the members being proposed by the club must be proposed by somebody who is either a director, a shareholder, or a signatory of that club. You would find that only in Article 13(2) of the statute, where you would need to be admitted as a member of the association. But once you are admitted as a member of the association, they treat you as a corporation. And as a corporation, my brother, we know that corporate law tells us that corporations are legal persons that act through natural persons. And by natural persons, it is inclusive. We know that the outline is directors or managing director for that matter. Then it includes officers of the corporation. So when an officer of a corporation acts for the corporation, and this is one of the issues we have, that they tell us that they have video evidence they've reviewed among other things. And in our submission, we told them that we want to be part of this review because that is the same communication the elections committee told us, that they have subsequently gone to do some investigation about this matter. And it tells them that this is what they are finding. But we know that the rules of natural justice require that when you get to establish or you get to this situation about somebody's application towards such a high office, you would want to give the opportunity to that person to be heard. And that is not just about us. That is what the statutes of the GFA provide. That in the event a candidate presents documents for application to the office, and there are inconsistencies or probably issues that will invalidate it, that's even assumed without admitting, the elections committee is mandated to bring it to the attention of the candidate and give the candidate at least 3 days period within which to amend those errors. Otherwise, the candidature is declared as invalid. The candidature is the application and the documents that come with it. And I've said that for as far as the documents are concerned, we don't have anything in the statutes that formalize what documents must be produced for the purposes of being eligible to stand office. But there's an eligibility criteria which does not include the presentation of any of these formal documents. That is where they have a problem.
Okay, so the issue has to do with the signatory who was supporting the nomination of your client. Do you not think, and this is even outside law, let's look at the governance, he wants to lead an association. Do you not think that he ought to have someone or ought to know that this person who is signing for him did not have the locus of the club? Should he not at least check that basic key fact before submitting the papers to the GFA, you don't think?
Before I answer that, I just want to add one significant point. That apart from that gentleman, there was also another supporting member of the association who had endorsed documents in support of George Afriyie. So in fact, in the case of George Afriyie, we had 6 members supporting his candidature, including these 2 persons I have mentioned. And like I said, they don't have any formal documents requiring that some particular officers or directors of a company are those mandated to sign documents to validate such support.
The appeals committee has said that claim of yours is false. It says, and I read, we note from the written submission of George Afriyie that he is asserting that he provided 6 members supporting his nomination. This is not true. The only members submitted in support of his nomination are 5.
Umaru, if you go back to the decision of the elections committee, you see, this is where they contradict themselves. If you go back to the decision of the elections committee, if you look at paragraph 2, what do we call it? Where is it? If you look at paragraph 2, IV, right? Paragraph 2, in fact, if you look at paragraph 2, II, and IV of the decision, I don't know whether you have it with you. Even the elections committee admit in their decision that they received 6 supporting documents. Their issue was that in the case of one of the supporting documents, the person had signed a statutory declaration. This was Nana Ameya Omenu of Techima 11 Wonders FC. He had signed a statutory declaration in support of George Afriyie, but had not endorsed the nomination form. And they say that Jeffrey Asari, who is the one in contention, had signed the form and also a statutory declaration. But he was not a director of the company, so he wasn't mandated to sign. And our argument is that when you go to the statutes and the regulations on elections of the GFA, we don't even have formal documentation to be completed by such persons in order to indicate their support of a candidate or otherwise. So that if you find a member, we are talking about members, a member of the association, whose officer or director has communicated to you by one formal process or the other that we are in support of this person's candidature, you ought to consider it in the context of eligibility to stand office. And eligibility to stand office has been what? Provided for in the statute. And they say that you would want to cross-check that person's application against what is required. And when the person falls short, let the person know that you this and this document. If you cannot provide it within this period, your application is deemed as invalid.
Okay. Let me just, in conclusion, say that you were disqualified, or your client was disqualified. He has appealed. That appeal has been dismissed. The options available for you, based on the reading of the GFA statutes, is that you cannot even appeal in ordinary courts of Ghana. You would have to go to the FIFA system. Is that an option you are going to explore, or you have other options locally you plan to explore?
I would answer by correcting your opinion that we cannot resort to the ordinary courts in Ghana. That is, as far as our opinion is concerned, not the case.
It's not my opinion, actually. Let me read for you the statute, the 2019 statute. Section 61, if you could go with me, arbitration. It says disputes in GFA or disputes affecting members of GFA, leagues, members of leagues, clubs, members of clubs, players and officials shall not be submitted to ordinary courts unless the FIFA regulations, these statutes, or binding legal provisions specifically provided for or stipulate recourse to ordinary courts. Such disputes, as specified in paragraph 1, shall be taken before the Court of Arbitration for Sports, CAS, in Lausanne, Switzerland.
Good. Now, I'll just point 2 things out to you. You see, the Article 61 says this about it. And then you would go to Article 58 that deals with appeal. Article 58(5) will tell you that apart from Lausanne, you can go to a national independent arbitration tribunal here in Ghana to deal with such an issue. So that is the first thing we need to note. That it's not only CAS that can deal with this matter. The second thing we need to note is that in the case we put before the appeals committee, we put a case including the breaches of the rules of natural justice, which by extensive law, and I don't want to bore you with citations, the decisions have been that when it comes to allegations of the breach of the rules of natural justice, these contractual agreements between parties, such as the statutes of the GFA, would not override the decisions or the authorities of the courts about them.
Good. So in 10 seconds, you would explore courts in Ghana. You're not going to CAS as yet.
We are going to go to CAS as far as the rules on GFA regulations are concerned. And that's the instructions I have. And we are exploring the situation where the courts in Ghana would explore the breaches of the rules of natural justice as far as George Afriyie's candidature to stand the office of president of GFA is concerned.
Very well.
So these are all available options to us.
Thank you. Thank you so much for speaking to us. That's Richmond Saka, his lawyer for George Afriyie, who has been disqualified from running as president of the GFA. Let me just conclude